Welcome to the Ask Junior Daily Judgment podcast. I'm Priya Sharma, and joining me today is Arjun Gupta.
Hello, everyone. We're excited to dive into today's important judgments. But before we begin, don't forget to like, subscribe, and share our podcast if you enjoy our daily legal breakdowns.
That's right. Your support helps us reach more listeners and continue providing in-depth analysis of the latest court decisions. Now let's get started with today's case. VOS Technologies India Private Limited versus the Principal Additional Director General and another. This case comes from the High Court of Delhi and was decided on December 10th, 2024.
This case revolves around a fascinating issue of delay in legal proceedings. Priya, could you shed some light on the key facts of the case?
Certainly. This case involves multiple petitioners, including VOS Technologies India Private Limited, Amira Technica Private Limited, and several other companies and individuals. They were facing show cause notices, SCNs, issued by the Directorate of Revenue Intelligence, DRI, and other customs authorities. These notices alleged violations of customs laws and were related to issues like customs duty assessments and classifications.
So basically, these companies were accused of potentially breaking customs regulations, and they were issued notices explaining why they might face penalties or consequences.
Exactly. However, the crux of the matter lies in the fact that these SCNs were issued years ago, some even dating back to 2006. The petitioners argued that the inordinate delay in finalizing the adjudication proceedings, some of which were pending for decades, violated principles of natural justice and reasonable timeframes for adjudication.
Wow, decades. That's a long time to be in legal limbo. What are the specific legal questions at the heart of this case?
The court grappled with several key questions. Firstly, does an inordinate delay in concluding adjudication proceedings under the Customs Act, Finance Act 1994, and the Central Goods and Services Tax Act 2017 provide sufficient grounds to quash those proceedings? Secondly, is the practice of repeatedly transferring matters to the call book, a mechanism to keep proceedings in abeyance without proper notice to the assessees in periodic review, legally valid? Thirdly, did the evolving legal landscape due to various Supreme Court judgments like the Syed Ali case in 2011, the Mangali Impex case, and the Canon India case in 2021, regarding the jurisdiction of DRI officers justify the delay in concluding adjudication proceedings? Fourth, does the phrase "where it is possible to do so," found in Section 28(9) of the Customs Act and Section 73(4)(b) of the Finance Act 1994, give unlimited discretion to authorities to delay adjudication? Fifth, did the legislative amendments through Finance Acts of 2018, 2020, and 2022 validate pending proceedings and protect them from being quashed due to delay? Finally, does failure to conclude adjudication within a reasonable time, despite no insurmountable constraints, violate principles of natural justice and warrant the quashing of proceedings?
Those are some complex questions. Let's talk about the ratio decidendi, the principle or rule of law on which the court based its decision.
The High Court of Delhi provided a clear and forceful message in this judgment. The court emphasized that matters with potential financial liabilities or penal consequences cannot be kept pending for years or decades. While statutes may provide flexibility, it's not a license for lethargy or indolence. The court ruled that authorities have to prove they were genuinely hindered and impeded in resolving disputes with reasonable speed and dispatch.
That makes sense. In other words, the authorities can't just hide behind the law and let these cases drag on indefinitely. They have to act diligently. But what about the call book procedure?
The court found that the practice of repeatedly placing cases in the call book without proper notice or review was not acceptable. The board's own instructions required affected parties to be informed, and periodic reviews were supposed to be conducted. The court found that the respondents, the DRI, and other customs authorities failed to follow these guidelines, resorting to a mechanical transfer of cases back and forth without applying any thought or reaching an opinion on individual cases.
So basically, the court saw the call book as a way to avoid making decisions, not a legitimate tool for handling complex cases.
Precisely. The court also addressed the impact of legal flux, meaning changes in legal interpretations through various Supreme Court judgments. While the court acknowledged that these judgments might have created some uncertainty regarding the DRI officer's jurisdiction, it emphasized that several legislative interventions through finance acts provided the respondents with the power to continue proceedings. For instance, Section 2811 was specifically inserted to validate proceedings initiated prior to July 2011. Yet, despite this legal backing, the respondents failed to act.
It seems like the authorities had ample opportunity to address these cases, even with the legal uncertainties. So, what did the court say about the phrase, where it is possible to do so, that appears in Section 28(9) of the Customs Act?
The court cited the SWAT group case to explain this phrase. It essentially means that where it is possible to do so only applies in situations where there are insurmountable exigencies, making further recourse impracticable or not possible. This is not a blanket excuse for inaction. It's meant to offer limited flexibility in genuine cases of impossibility, not unlimited discretion to delay.
It sounds like the court is drawing a strong line here. They're saying that delays are only justified if there are truly insurmountable barriers, not just convenience or a lack of motivation.
Absolutely. The court also examined the impact of legislative amendments through finance acts of 2018, 2020, and 2022. These amendments were meant to address jurisdictional issues and validate pending proceedings. But again, the court found that the respondents continued to abstain from taking proactive steps despite these legislative interventions empowering them to proceed.
It seems like these authorities were deliberately stalling, even after the law itself provided them with the tools to act. And what about the principles of natural justice?
The court underscored that statutory authorities are bound to conclude adjudication proceedings with due expedition. When faced with delays, they must demonstrate either the impracticability of acting or the existence of factors beyond their control that prevent expeditious completion. The respondents failed to establish any insurmountable constraint that could be recognized in law as impeding their ability to conclude the pending adjudications.
That's a powerful statement. The court is essentially saying that the respondents had no valid excuse for not finishing these cases in a reasonable time. So what were the implications of this judgment?
This judgment has far-reaching implications for future cases involving similar issues. It sets a firm precedent, making it very difficult for authorities to justify excessive delays in adjudication proceedings. The court quashed all the SCNs and final adjudication orders challenged in these petitions.
So, all the notices were revoked because of the delays?
Exactly. The court emphasized that matters with financial or penal implications cannot remain in limbo indefinitely. All proceedings were directed to be terminated with immediate effect, providing finality to these long-pending matters.
This judgment definitely makes it clear that authorities cannot just let legal processes drag on for years without justification. But Priya, do you think there were any dissenting opinions or controversies surrounding this judgment?
Interestingly, there weren't any dissenting opinions in this case. However, it is worth mentioning that the court's stance on the call book procedure and its emphasis on a strict interpretation of where it is possible to do so could potentially lead to debates in future cases.
That's an important point. And how does this judgment relate to previous cases or laws?
This judgment builds on the precedent set by previous Supreme Court judgments like the Sayed Ali case, the Mangali Impex case, and the Canon India case. It reinforces the principle that authorities must act diligently and conclude adjudications within a reasonable time frame.
It's fascinating to see how the court uses previous cases to establish its own reasoning and interpret existing laws. This is a great example of how law evolves and adapts over time, responding to changing circumstances.
Indeed. To illustrate this concept further, let's imagine a hypothetical scenario. Let's say you're applying for a driver's license. You submit all the necessary documentation, and the Motor Vehicles Department says it will take 6 months to process your application. Now imagine you return after 10 years and they say they haven't processed your application yet. Would you be happy?
Definitely not. That would be completely unreasonable, and you would have every right to question the delay. The court in this case is essentially saying the same thing about legal proceedings. There are time limits that must be respected, and authorities can't just let cases sit for decades without a proper explanation.
That's a perfect analogy. We hope you found our discussion informative and engaging.
Before we sign off, we'd like to remind our listeners once again to like, subscribe, and share our podcast. Your support means the world to us and helps us continue bringing you daily updates on the most important legal decisions. Stom.
Absolutely. And don't forget to tune in tomorrow for another exciting episode. Until then, this is Priya Sharma.
And Arjun Gupta, signing off. Thanks for listening to the Ask Junior Daily Judgment podcast.